Good morning and welcome to the Center for New American Security. I'm Carrie Cordero, a senior fellow here at CNAS, and we are going to have a conversation today that is related to the current events in terms of deployment of the National Guard throughout the country, as well as the calling up of military personnel in connection with the protests that are taking place over the course of the last week in Los Angeles, and some additional protests that have been popping up at different parts of the country. I am joined today by two of my absolute go-to law professors who are experts on national security law and military law and issues of domestic deployment. So I'm joined today by Claire Finkelstein, who is a professor at the University of Pennsylvania, both of law and of philosophy. She is also the director of the Center for Ethics and the Rule of Law at the University of Pennsylvania. Claire has written for a recent commentary series that we published here at CNAS that is focused on Posse Comitatus and domestic deployment of the military and the National Guard. And I'm absolutely thrilled to have her expertise. She is an expert on the law of armed conflict, military ethics, national security law, and professional ethics. We're also joined today by Professor Mark Nevitt, who is a professor at Emory Law School. Mark is, by way of background, also a former Navy JAG. He was also a former naval aviator, and then he has continued his career as a law professor. He has written extensively on the issues of domestic deployment of the military. So again, two of just my absolute go-tos on this particular issue. And so Mark and Claire, I'm really grateful that you are joining us for this conversation today.
Thanks for having us, Carrie.
I'm going to start off let's just level set for a second in terms of the facts that currently as we know them. So we now are in what is the 7th day of varying levels of protest activity in LA in particular. We just passed the second night of a curfew that was put in place by the mayor of LA, which does, from my observations of reporting that's going on, does seem to have helped from a law enforcement perspective and from a perspective of settling things down somewhat. So that curfew has been effective. We also, on the legal front, later on today, there is going to be a hearing in federal court in San Francisco that is going to take up the case that the governor of California has brought against the administration and the president, challenging the president's use of the National Guard and potentially more military under a provision of Title X, where the president has federalized the Guard and called them into service. So that case is going to come up today. California filed their brief very quickly. The Department of Justice has responded in a lengthy filing, and so we'll see what happens in that case. And we're going to dive more into what both Claire and Mark think might happen in that case a little bit later on in the discussion here. But our focus today is to dive into the legal aspects of the current deployment of National Guard here in the country, and also this additional calling up of Marines. By my observation of public reporting that's happened so far, in terms of their actual activities, it looks like the National Guard has engaged in what the administration is characterizing as protective activities. I haven't yet seen reporting that the Marines have been actually engaged in anything in the city other than reported training that they have been involved in. So that seems to be where things are right now. And part of our conversation is going to focus on how the actual activities that they are engaged on connects to what the legal analysis is going to be. So with that, I am going to start off and ask you, Professor Mark Nevitt, can you kick us off with an overview of the legal framework that is in place, what authorities has the president relied on so far to engage the military in this way, and just walk us through in a snapshot version how the law is coming into play in this current situation.
Sure, great. And so as a general matter, as Carrie alluded to, federal military forces are barred from executing the laws under the 1878 Posse Comitatus Act, but that can be overcome if either there's a statutory exception or some kind of constitutional provision that expressly authorizes the military to be used in a law enforcement capacity. So the president is really arguing two different authorities for the California National Guard and one authority for the Marine deployment. For the California National Guard, the president is relying upon what's called 10 USC 12406. It's kind of a mouthful. It's a rarely used authority. It's been on the books for over a century, but essentially authorizes the president to federalize the National Guard in three circumstances. And the president is arguing that there is a rebellion, and this rebellion is preventing him from executing the laws against the authority of the U.S. government. Again, rarely invoked. It was famously invoked in 1970 when President Nixon essentially federalized the postal workers during a postal strike. This is a much different context. And I will say the statute is sort of odd. It doesn't really contemplate a circumstance like we have in California, whereby the governor of California does not want the California National Guard to be federalized. There's a provision in this statute that says that all orders shall be issued through the governors. But of course, what if the governor refuses to issue orders? What if he objects to this? This is quite different from the 1970 postal strike, where every sort of governor agreed to sort of deliver their constituents' mail. It's bad for elections if your constituents aren't getting mail. So that's the core crux of the California lawsuit. But there's another authority that the president is relying upon, which is constitutional, not statutory. There's an Article 2 protective power, which the OLC opinions and some case law have addressed. And it can be found, I think, mostly in the take care clause of the Constitution on the Article 2. And it's limited scope to the federal property, federal personnel, federal protection. But there seems to be some sort of inherent authority that the president has a legal basis to assert to protect the ICE and federal buildings that are in Los Angeles. So that's just on the California National Guard itself. Mm-hmm. For the Marines, of course, the Posse Comitatus Act restrictions fully apply, full stop. There's been no Insurrection Act invocation to date. That would be a statutory exception, the one statutory exception that would be in play to get the Marines under around this Posse Comitatus Act prohibitions. And 12406 has nothing to do with the Marine Corps. It's all about the California National Guard. And the president is asserting and delegating really to Secretary Hegseth the authority to take protective activities as Hegseth deems necessary to protect federal property. So more of an Article 2 take care clause authority. And I should say that the military and the Marines oftentimes do indirect support, what's called direct support to civil authorities. This is quite unique because this is not a natural disaster response or emergency response. This is really a law enforcement type mission. But those are sort of the baseline authorities that are at play here, Carrie.
Okay. All right. That's great. Claire, I'm going to come to you in a second. Before I do, I just want to mention to our virtual viewers, I'm looking down a little bit at an iPad that I have in front of me, because if folks are watching virtually and you want to send a question in for us to look at as the discussion continues, you can either do that on the CNAS website at cnas.org/live. Or if you're watching this on the X platform, you can use the hashtag CNAS2025. And from time to time, I'm going to look to my side a little bit and look to see if there's questions that we can work into our conversation, because we know that members of the public, our policy audience might want to engage with us and put a question to the group here. Claire, okay, I want to come to you. Before we dive in, like more specifically thinking about, okay, what actually are the National Guard troops doing? What potentially could the Marines be engaged in? And how does that play into the legal authorities that have been cited so far? Can you, Law Professor Finkelstein, give us a quick 101 on the law of Posse Comitatus, which you've written on in our commentary series that's on our website? Just help us understand what that tells military, what they can do and what they can't do in the United States.
Good. Thanks so much, Carrie. And thanks for putting this important forum together. And Mark's summary was really perfect. Posse Comitatus has come to play a very important role because it really stands for the principle of how we organize civilian-military relations in this country, that there is a division between what the military does, which is to mostly fight foreign wars, and law enforcement activities, which has to do with the US population. And it's important that we keep the two separate, that we understand what is the distinction between law enforcement, which has to do with fighting crime in this country, and what is a military operation. And what we're seeing increasingly, and this is a trend that, of course, predates the current moment, is a blending of those two functions. And it's a very concerning trend. So Posse Comitatus says that federalized troops, or federal troops in general, cannot serve law enforcement functions. It is a criminal statute, so that anyone who is involved in pressing federal troops into service to serve a law enforcement function could be subject to a criminal penalty. And that means that federal troops cannot engage in arrests. They cannot engage in detentions. They cannot engage in all of the things that our police routinely do. And that may seem like a very strange thing, but if you think about it, it makes an awful lot of sense, because that's not what they're trained to do. And the military will tell you that up, down, and sideways. They don't want to be making arrests. This is not what they're there for. They're there, for the most part, to be fighting foreign wars.
So that's great. So a question that I've got that also I've seen raised a little bit during the course of this week is, so if I'm hearing it correctly, what you just described, Claire, so that absolutely Posse Comitatus would apply to the Marines, that, again, we haven't seen any evidence that they are on the streets of LA or anywhere else. They've just been sort of identified as in training to potentially be available. But since the president has federalized the National Guard, does that then take them into the realm of Posse Comitatus covering them?
Absolutely. So there are different ways to federalize National Guard troops, and the 12406 authority that Mark mentioned is one that is generally not considered an exception to Posse Comitatus in the way that the Insurrection Act, for example, would be. And for whatever reason, and we don't really know why, the president decided not to proceed via the Insurrection Act, which has been the more common one, the more common way of federalizing troops, but instead decided to proceed via this 12406, which, as Mark mentioned, the only precedent we really have is when President Nixon decided to use that authority to federalize New York National Guard to make sure that the mail was being delivered. But it's not an exception to Posse Comitatus. So the 4,000 California National Guard troops that have been federalized also can't engage in law enforcement practices. Now, this has gotten very complicated just in the last 24 hours because there are headlines saying that they are now authorized to engage in detentions, namely that if there is a lawbreaker, they can hold that lawbreaker until some law enforcement agent arrives and can properly arrest them. If you think about all the things that our police do and that the LAPD are trained to do, namely read somebody their Miranda rights, make sure that they are being properly arrested, taken into custody.
Fourth Amendment, all the Fourth Amendment protections that are in play.
Exactly. Having evidence at a scene preserved. Our troops are not trained to do that. And it will be important for prosecution, not just for the rights of the person being detained and possibly arrested, that the LAPD are the ones to handle the law enforcement piece, because those individuals may later be prosecuted and they know how to handle evidence on the scene.
All right, so Claire, you mentioned that 12406, and Mark had talked about this earlier, is sort of an unusual provision, and it's not currently clear why the administration and why the president use that authority as opposed to the Insurrection Act. I've got a couple theories about it for why they might have used it, but before we get there, Mark, let's shift a little bit and let's dive into the suit that the California governor has brought. We've got this hearing today in federal court. What California has basically asked the courts to do, the federal courts to do, is to say that the president can't federalize the troops. And it seems to me like California wants the courts to look behind the judgment that the president has made in this particular case. You were quoted, Mark, in the Wall Street Journal this morning as saying that this is truly a case of first impression. So talk us through a little bit how you think the federal judge is going to be taking up this hearing later on today.
Sure. So, and I just want to co-sign to Claire's comments on 10 U.S.C. 12406 to the extent that the Insurrection Act clearly is an exception to the Posse Comitatus Act. I agree. I think that the 12406 authority, I think, is a case of first impression. And there's different commentaries out there about, is that a bona fide exception? The challenge right now, I think, is that the president is linking the statutory authority with protection of ICE and the U.S. government. So we don't really know what exactly the mission is for the California National Guard, which is a problem in its own right, beyond protecting personnel and federal property. So let's just maybe start with what California is asking for and their litigation. They're seeking a declaration that Hegseth's order calling the National Guard to federal service is unlawful, and they're seeking injunctive relief to prohibit federalizing and deploying the California National Guard without first going through the governor as part of the order's issuance requirement that I mentioned earlier. And the government's, the lawsuit from California is really focused on the 12406. And in part, there's a protective power authority that they kind of are addressing as well. But the real focus is on this order's issuance authority that they believe is violated. And I believe the 12406 is a way to think about it is in two sort of different buckets. The first bucket is in the activation bucket. In other words, is the President Trump lawfully placed the California National Guard under federal service pursuant to one of these three statutory triggers? Was there a rebellion or some sort of danger of rebellion against the authority of the U.S. government? There is no definition in the statute. You can imagine a federal judge not being particularly excited to really opine on what a rebellion is or to second guess the president. So I think on the activation piece, I think that the government has a pretty strong argument. On the orders issuance piece,
the federal government.
The federal government. I'm sorry. There's two sovereigns here. Thank you. So on the orders issuance piece, the second bucket is sort of operationalization. Great. The California National Guard is now federalized. Maybe the Judge Breyer doesn't want to address, get into the Black's Law Dictionary battles that are ongoing between the two briefs of what exactly is a rebellion. So then you want to do something with the California National Guard, right? So that's their whole point of being federalized in the first place. So that's the operationalization bucket. And the orders, factually did not go through Governor Newsom, right? It was between basically the Secretary Hegseth and the California Adjutant General. And the command was transferred from the Adjutant General of California to Northern Command. So facially, you would think that this is a violation of the statute. Go back and do your homework and have some sort of way to get the governor involved. The problem here for California is that their law doesn't do them any favors. The California state law states that the Adjutant General, and I quote, shall issue all orders in the name of the governor. So California state law is acting on, gives the Adjutant General that sort of delegated authority. So I think it's the federal government has the better case based upon the California state law of delegation to the Adjutant General. And even if they were to win on 12406, the protective power is still there. That's an independent constitutional authority. And the judge, I think, is going to be very, very reluctant to craft a decision to give what the California is asking in this case.
Yeah, that's really an important distinction between what the text of the federal statute says, which we're talking about Title 10, USC 12406. That's 12406 that we're referring to, and the potential way that California state law plays in, because the text of 12406 says the governor. It doesn't say the adjutant general. It says the governor. And so California is relying on that, but then it does sound like their own state law interprets it in a little different way. Claire, what's your thinking about the California case? I'm particularly interested in whether you think the judge is going to second guess the president's judgment, as Mark was describing, in terms of the threat environment, so to speak. The different statutes have rules, words like invasion and rebellion and things like that. But the actual facts that are described in the Department of Justice's brief, there's a couple pages in there that describe violence that, according to the Justice Department's brief, was perpetrated by protesters against federal agents around, I think it's ICE facilities or ERO, which is part of Department of Homeland Security facilities in LA. And there's some pretty aggressive violent activities that are described in that brief. Do you think the court is going to second guess that?
Yeah. So first, let me start with the 12406 matter, because I think the California case is stronger than Mark seems to think it is. So
okay, yeah. Why so?
And we've talked about some of the Mark, you did flag the issues that are in California's camp, but let me kind of lean into them a little bit more, because I actually think that California case is quite strong, but I'll come to in a minute whether or not I think a judge is actually going to do anything about it.
Great.
So, I mean, 12406, as you both rightly noted, says that orders for these purposes shall be issued through the governors of the states. Now, that should take priority over California law, right? Because federal law preempts state law. So to the extent that there's a conflict between California law and federal law on this issue, 12406 is going to win out. And moreover, it's very supported by practice. Mm-hmm. So we have very few instances in which guardsmen are mobilized and federalized by presidents without coordination with the governor. There's almost no precedent. We have very important precedent in the case of civil rights instances in desegregation. But in that case, for example, the case of Little Rock, which is the biggest example that we have, there was a Supreme Court order backing the president up. And so it's really I agree with Mark, it's sort of a case of first impression, because the federal government is operating on very weak grounds to begin with as a basis for overriding the governor. Now, where that plays a role is in the rebellion part of 12406, because it's very implausible to say that what's going on rises to the level of a rebellion. On the scale, yes, there's been violence. There's been burning of self-driving cars, burning of flags. There's been some, personal assaults on officers and so on. But number one, the violence absolutely ratcheted up after federal officers got there. There's no question that the presence of federal officers was incendiary and that it increased the violence. So the question is whether or not the initial move to federalize was justified under the authority that they used. They would frankly have had an easier time going under the Insurrection Act, because contrary to the name, the Insurrection Act doesn't actually require an insurrection, but 12406 requires a rebellion. And I think it's a problem for the federal government right now, because it's very implausible to think that the fairly ordinary law breaking that's going on as far as demonstrations getting out of control rises to the level of a rebellion. Mm-hmm. As to whether or not a federal court, though, is actually going to do something about it, that's another matter, because federal courts are very, very skittish about getting involved in telling a president, and probably especially this president, that they've overstepped the bounds. We all know that there are very few cases, and Mark is an expert in this as well, something we both study, and you are as well, Carrie, in which courts have been willing to say to presidents, you have overstepped the bounds. This case is a very important one, and it's possible that a federal court will be willing to step in, but I could also see a federal court saying, look, this is a political question, and we're not going to get involved. Or there is a national security justification. The civil case that went to court after Lafayette Square was dismissed on national security grounds, as well as immunity grounds. Here, there's no issue of immunity because we're talking about an injunction. But I think it's very possible that a court will just say, it's within the discretion of the president, even if it's a very implausible case for 12406.
That's great. So, Mark, let me ask you, in terms of what the either National Guard or if the Secretary of Defense were to give an order for the Marines to actually engage in some type of activity, can you talk to Mark, both probably drawing most specifically from your JAG experience as well as your scholarship. Can you just explain to us what the rules of the road are, and how are the military officers trained in terms of use of force? This is a question that somebody has written in from our virtual audience, wanting to understand what is the actual guidelines that military officers would be following when it comes to whether or not they can use force domestically.
Yeah, great. So maybe I'll start with that because it kind of highlights this disconnect, as Claire so eloquently outlined, between civilian law enforcement and military operations. So rules of engagement are not in place here. And for the most part, the military members, the Marines at 29 Palms, that is part of their culture. What is the ROE? From some sort of combat environment, operational environment, Iraq, Afghanistan, fill in the blank, much more aggressive, oversee deployment sort of rules of engagement in an IHL, international humanitarian law type of context, or at least a very uncertain operational environment. Quite the contrary, what's happening here in California is rules for the use of force. And these terms are really, really important because those are law enforcement rules for force in engaging with the civilians that are in California. So all full constitutional protections, search, seizure, First Amendment, fully apply on the rules for use of force. It's the law enforcement rules that are in place. And my understanding, and from reading the NORTHCOM letters, is that the Marines have been trained on the rules for use of force, the standing rules of force, which would be in place, as well as de-escalation and tactics and training associated with that. But there's a danger, a little bit of a danger in having more of the Marines who have more integrated the ROE type context than the RUF context. If I can just give you one quick example from the Los Angeles riots in 1992, there's different terminologies with rules for use of force and rules of engagement. And LAPD was accompanied by Marines who were activated under the Insurrection Act in 1992. The Marines were accompanying the LAPD as part of a domestic, basically intervention in a home. And the LAPD officer asked the 3 or 4 Marines with him to say, essentially, cover me. And when you say cover me in the context of a rules of engagement context, that means lay down covering fire as you advance. In a law enforcement context, that means put your trigger off safety and be ready to engage if needed. So the Marines actually did what they were trained to do under the ROE, not rules for use of force, and laid down 200 bullets into the apartment complex. No one lost their lives, thank God, but it does kind of show that disconnect between rules of engagement and rules of use of force. And it's very, very untraditional to do this on such a last minute notice.
And this is why we're focusing on this, right? Because one of the overriding issues and why we all are engaging on this issue as national security lawyers, why you guys have contributed your time along with co-authors in our commentary series, Ohio State professor Dakota Rudisil, the Brennan Center's Liza Goitin, both of you, as well as our own research assistant Taryn Sylvester, have all written pieces focused on National Guard and potential domestic uses. But it's why we're focused on this issue, because there really are risks when we are talking about the use of military domestically for law enforcement or protective purposes, but here in the United States and in U.S. cities. So I want to I want to unpack a little bit the purpose that the military personnel are being sent to LA according to the administration's arguments. You guys both have mentioned the Insurrection Act, and the Insurrection Act has not been invoked in this scenario, which is the way that we looking at modern history would have expected a president to use in this type of situation, or in a situation that maybe had even more violence than we've seen so far. But the Insurrection Act was not used, and instead the president's using both what Mark and Claire have described as this inherent authority under executive power to provide protective services. And then they also are using 12406. Now, the interesting thing about 12406 is it also talks about a potential invasion. And this is where I'm going to float a theory here with you guys. You guys tell me what you think. There is a common thread, I think, that can be drawn from the invocation of language of invasion in this context, justifying the use of military personnel, and arguments that the administration is making in its broader immigration enforcement policy priority. And the word invasion also comes up in the Alien Enemies Act and another provision of sort of historical law that the administration has used. So my question to you, Mark, maybe I'll come to you first, and then Claire, is, Mark, is your assessment of the current theory that the administration is using based more on the fact that they are saying they need these forces to provide protection for federal personnel and facilities? Or is it that they are really relying on what is this administration's theory that illegal immigration constitutes an invasion? And that's why they've gone to 12406 versus the Insurrection Act. Any thoughts on that?
Sure. So, and to be clear, so I think it's both, Carrie. I mean, 12406 doesn't have the language of invasion, but I agree with you completely that this administration, from the day one of office in their national emergencies declaration till present, has called the immigration issue and migrants crossing the border as a, quote, invasion. So they're using this sort of national security language, and they have an executive order from January of 2020 that really inextricably links the Department of Homeland Security and the Department of Defense into this mission. My sense, I don't want to speculate too much. I just want to say that I think the military is being intertwined with this in ways that are just really, really novel. And just maybe one side example to highlight this, the military base that is at the southern border itself, right, is part of this design to sort of get at this sort of invasion rhetoric and this idea that we need to have a military base, and that gives the military greater authorities. And so I think it's a broader pattern, I think, of essentially integrating the military with the immigration mission.
So Claire, yeah, if we look at 12406 and it talks about different provisions when the United States is either invaded or in danger of invasion by a foreign nation, obviously not a situation here, but I do wonder if the administration looks at that. And then it also talks about rebellion and danger of rebellion.
Right. So they've gone with rebellion. So the invasion language is really just more conspiracy theory ecosystem. They're saying, oh my gosh, some of the protesters are flying Mexican flags. This is an invasion, but that's not. It's not a crime.
It's not the legal theory that they're relying on.
So in fact, the theory is rebellion, and rebellion is the piece that the California complaint answers, and correctly so. So they're not offering it's too implausible to think that the protests in Los Angeles actually rise to the level of invasion. There's no evidence that there's foreign infiltration here. I think, as Mark suggested, that's just sort of more what's being used to support border strength and trying to build up operations at the border and trying to gain support in more of a political context for the immigration operations and Customs and Border Patrol operations. There is an issue here, though, that I want to flag, which does have to do with the immigration and Customs and Border Patrol aspect of this, that ties it in with Posse Comitatus, which is that when you have federal troops who are supposed to cover for CBP and ICE agents, what's concerning here is that it may bring them actually under the authority of those civil agents. And that's not the way the chain of command in the military is supposed to work. So the relationship between federalized troops and Marines on the one hand, and the federal agents who are from ICE and CBP is really ill thought out here and really not well determined. I draw our attention to this because in the agreements that have been going on for a while, that Mark has recently written about and I wrote about in my piece for your series, Carrie, the 287G agreements that have gone on between the various National Guards, red state National Guards, and the federal government. Those National Guardsmen are supposed to be designated as law enforcement agents. And that means that they are under the command of CBP agents and ICE. And that makes them law enforcement officers. But these federal troops can't be designated that way because of Posse Comitatus, right? They're not law enforcement agents. So this shows the muddle that this has put us in. I think that the object here, the real object, is not even immigration. As extreme as the Trump administration's policies may be on deportations and immigrations, the real object here is control, is a battle with the governors and wresting control of the guard from the governors.
All right, that's great. So we've got about 5 minutes left, and I want to focus. Let's focus on the governors, and let's focus for the next our remaining time here on what are the paths out of this situation. So we've got a question that has been written in on the online chat asking about how the legal calculation would change if the president uses authority, I think more broadly in other states, without the consent of governors. As of last night, my understanding from public reporting was that Governor Abbott of Texas has already publicly acknowledged and said that he is going to sort of have his National Guard ready to go. That seems to me, and he's a Republican governor, but that actually seems to me an interesting strategy for a variety of governors, including those in Democratic states or in states that have cities where these types of protests maybe are more likely to spread to. That, you know, is one path out of this, that the governors more visibly say, we're going to explore using our National Guard. We have our National Guard ready if we have a situation that needs that. And that basically would tell the president, you don't need to federalize in my state. You don't need to step in here. I got it under control.
Well, and in fact, this has already been tried by the governor of New Mexico, who's anticipating this, because this has been quietly bubbling along for a while. The governor of New Mexico said, I'm calling out my National Guard to do highway patrol. We've got an emergency on the highways, right? And then when the feds come calling, she's able to say, I'm sorry, our National Guard is already tied up with a state emergency. So getting out there and deploying your National Guard as a governor is a strategy to say, I've already deployed them. That'll get us into new uncharted territory. Can federalization occur once Guard has already been mobilized? And I think courts are likely to uphold that as well and say that presidents can wrest control of an already mobilized Guard and bring them under federal control. But it would be harder. It would be harder to do that once they're already out there and mobilized, especially if they're mobilized for the same purpose for which the federalization would mobilize them.
Mark, I'm going to ask you in a second. I want you to offer thoughts on sort of where you see the paths out of this are, but I do want to hover for a second on Claire's point about other missions, because one of the issues that we've been exploring here in some of the writing that's in the commentary series is that there are so many missions currently that the National Guard is called upon for, really important critical missions, that it does strike me from a national security perspective that there's a real readiness potential issue if National Guard is used too much for these law enforcement, or in this case, what the administration is calling protective functions. I say that as we are at the beginning of a summer where we can be sure that there will be wildfires, we can be sure that there will be hurricanes, we can be sure that there will be some sort of natural disaster that in some state most likely requires some National Guard assistance. And so there is an issue where they need to be ready and prepared to perform that critical need in different parts of the country. Mark, your thoughts?
I agree. I think that the National Guard's men and women are brave, dedicated public servants. They're also a very stressed force. And there's 2 or 3 things that have happened the last decade that have highlighted that. One, we've had a more operational National Guard. We had National Guard men and women bravely go into Iraq and Afghanistan as part of the total force. The National Guard head sits on the joint staff. It's much more operational than ever before in American history. And so many of those service members are still performing duties. Second, COVID-19, the largest domestic military deployment in modern American history. People forget that. Just a few years ago, we had National Guard men and women doing everything from teaching schools to giving vaccines to fill in the blank. And now with disasters, emergency response, firefighting, things along those lines. And that's exactly in Governor Newsom's brief. He's highlighting this. There's a cost to this, to readiness and emergency response that will be inflicted upon the state National Guard. So it's a real issue. I think you may play it out with recruiting, retention, and things along those lines. Remember, many of these National Guard members have day jobs, and now they're going to Los Angeles. They have to tell their employer. It's logistically very challenging for the National Guard men and women families.
Yeah, and let's remember that we are coming into. There have been terrible fires in California. This figures prominently in the California complaint, but also in the fall, as we if this plays out through the summer and we come into the early fall, where there are usually terrible fires in California, this could pose a huge problem, because California needs to rely on the availability of its guardsmen to fight those fires.
Yeah, well, I'm glad that we were able to get to some of the operational considerations that that certainly are going to be important in the coming days, weeks, and months. And thank you to Claire Finkelstein and Mark Nevitt for the really outstanding conversation and contribution digging into the legal issues. We'll see what happens in the hearing this afternoon in California on the case between California and the federal government. And I know that we'll all continue to stay engaged on these issues. Mark and Claire, thank you so much for joining us today. And thanks to everybody who joined us in our virtual conversation. Appreciate your engagement with this work as we continue to look at these issues of domestic deployment, the National Guard, and the rule of law here at the Center for New American Security.